Hello, reporter room investigator. Judge sets the date for the trial. So I just wanted to let you know I am right here. I am ready for the post, watching for it. And we're going to be going through some things leading up to this while people come on in. If you haven't subscribed, please. Like, share, and leave a comment. So my name is Jessica Davies. I'm an investigative journalist. My job is to investigate crimes, criminals, and potential suspects and show you how to do the same thing. So if you haven't subscribed, please do. I am going to be sharing my opinion, and the hearing starts at 4 p.m. We're getting started early because we're going to do a little bit of a pre-show here. I do want to say a quick thank you to this is the first time I've streamed one of these. I just want to thank our producers, George Brown, Jane J., and Sasha Angel, and our channel members. I'd also like to thank our mods. Our head mod is 6 Cents Amelia. I believe I saw her in the chat. And if you'd like to become a channel member and have your name show up, just hit the join button. This is 6 Cents Amelia. She's our head mod. So thank you to our mods, our subscribers, and to our awesome channel members. All right. So today the hearing is starting. I am here. I'm ready. It's going to be posted and we're going to watch it together as a YouTube community. But we're going to start off talking a little bit about Papa Roger. So the hearing, I just wanted to show you I am here. I'm ready to go. It starts at 4. We will go to it, but we're going to do a little bit of a pre-show here. Show links from Bryan to Maddie.
He was in fact fired.
This is Reporter Room with Jessica Della Davies.
Hello, Reporter Room investigators. Oh my gosh, we have so much stuff to get into on the Bryan Kohberger case. Let's get started. My name is Jessica Della Davies. I'm an investigator. I just told you this. Okay. They have BK's DNA on the K-bar knife sheath found underneath and to the side of Maddie Mogan. 3. They have an eyewitness. Dylan reports seeing a man dressed all in black who is taller than 5'10", has an athletic build but not muscular. He was wearing a mask and had bushy eyebrows. This description does match BK. A white Hyundai Elantra circling the crime scene 3 times before finally parking around 4:04 a.m. on November 13th of 2022. This Hyundai Elantra happens to be missing a front plate, and it's turn my mic off. This is why I don't turn my mic off, guys. Okay, so you couldn't hear any of what I just said on Papa Roger? All right, let me go through it. I'm so sorry. One more time. Okay, so many people think that this was Papa Roger, and I'm so sorry. I won't turn my mic off again. So I'm going to go through both Facebook and Reddit. So we're going to be going through the other account, which is called Inside Looking, that was also attributed to the same person. And we don't know if this was a member of law enforcement or if this was Bryan Kohberger or someone connected to the case. But so it says that they believe that he, and they're talking about Bryan Kohberger, was participating in these groups. And I am talking about this case in terms of Bryan Kohberger because he's the only one who's been indicted. He's the only one who's been arrested. He's the only one who's sitting in jail right now. So I am talking about this case in terms of him, but he is innocent until proven guilty. So in one of the social media posts, he went as far as to explain that the type of instrument, I'm watching my words, was a sharp knife, and the police had already had the knife sheath. But this turned out to be really, really close to the information. And this was before we were told. This is before we were told about the K-bar knife. So look at this. He writes on November 30th. This is Papa Roger. I was in this Facebook group. I'm not anymore, but I was at the time of the evidence released. I'm watching my words. The weapon has been consistent as a fixed blade knife. How did he know this on November 30th? This leads me to believe they found the sheath. Again, how did he know this on November 30th? The evidence was released prior to, and I'm not going to watch my words there. So is this Bryan Kohberger? So one user said, I took screenshots of everything Papa Roger posted. This is one of the creepiest. He posted that in answer to the question as to why the perpetrator chose this house, Papa Roger simply responded with the word, excellent. That is really creepy. That is really creepy. If this was just a random guy, this particular user feels like his response would have been something different besides excellent. It almost feels like he was cheering on this. So how did he know all this? And then, so this is I'll just blow this up so you guys can see it. And I am keeping an eye out. I just want you to know we are going to go live as soon as it's there. It's just not starting yet. We're doing a little bit of a pre-show. Okay, so that was in the discussion group on Facebook. And then we have this inside looking post. So a lot of people feel like this was the same person. Speculation. The person who did this, I'm just watching my words, parked behind the house, approached the property through the tree line, entered the sliding doors. We know that's true, and left it open. Don't know about that, but this is an awful lot of detail. Committed the crimes and exited the sliding door. We know from Dylan and from Bethany also saw somebody without anything going out those patio doors. One knife, according to the coroner's statement. Now, he does get the time wrong because we know from seeing that Hyundai Elantra circle the house 3 times and finally doing that kind of a 3-point turn and parking that the car pulled up at around 4:04 a.m. Vehicle left skid marks upon exit. We don't know that yet, but I do think it's interesting, and I'm curious what you guys think. Was this inside looking account, and was this Papa Roger account, was this Bryan Kohberger? What do you guys think? Hopefully you guys could hear me on that one. And I'm so sorry that I did it without the audio the first time. Okay, so let's see where we are in the chat. What do you guys think? Questions and queries are welcome. I really do want to know what you guys are thinking. The sound should be on. I'm on. Can you guys hear me? Put a 1 in the chat if you can hear me. Can you guys hear me okay? Laura says she does think it is him. Thank you. I think I have a little bit of a delay on a 1. Okay, you guys can hear me. Okay. I'm so sorry about that. I do have the channel up for Judge John Judge. I just want to show you we are waiting. Okay, I just don't have it up yet, so we're doing a pre-show while we wait. But I'm not going to let you guys miss it. Don't worry. Okay, so you guys can hear me. Great. Leslie says lots of laughs. It was me. Sorry, that was my sound. What was off? Okay, scared me because I do sometimes talk without the microphone on. David says he does think it was BK. And Mike says BK looks like Papa Roger. Yeah. And this is not him. This is an artist rendering um who did this, but you just wonder if he selected it because it does resemble him. The ears are different. I don't think this is not a portrait of himself. This is not a self-portrait. This would have been something he would have found on the internet. So you're right, Patricia. Jesse thinks it was BK as well. All right. Well, I think that's really interesting. In law enforcement, but I want to share a little bit more about Dylan in just a moment. So please stay with us. Is Ann Taylor and the BK defense team, are they stalling, or do they legitimately have so much information that they need more time to go through with it? And what do you think about prosecutor Bill Thompson going for a capital case? Are they overcharging in this case, or do they have a lot more evidence that we just have not seen yet? Dateline NBC also lent credence to the fact that BK created an anonymous Facebook account to post facts about the Idaho student crimes and was using the alias Papa Roger. In fact, according to Dateline NBC, law enforcement officers are convinced, quote, convinced, BK is behind that account. This is probably because Papa Roger had almost psychic-like predictions about this case. So either Papa Roger had to be a member of law enforcement, and some people have theorized this, and they think that Papa Roger stands for police reconnaissance, the P and the R in Papa Roger. But I believe it's more likely that it was BK than it was law enforcement. Let me know what you think about all of this in the comment section below. I love reading your comments. Do we always have to agree with each other, or is it okay that we don't always agree? Because I think the best way to learn about new information is to share constructively with each other all of the information that we have. And this way, everyone can make up their own minds about it. And that's what Reporter Room is. It's a critical thinkers channel. So the Papa Roger account on Facebook mentioned the knife sheath being left at the crime scene a full month before it was mentioned to us, the public. We did not know about the knife sheath, yet Papa Roger was posting about it on Facebook. Here are the receipts. What do you guys think? So he was posting about this a full month before we knew anything about it. A full month is, that's a lot of time. So, I think that's really interesting. And just wanted to run that by you. And I also want to talk about, and I just want to let you know, I am here ready to go with this once we go live. We're just not there yet. But I do want to, I am ready to go with Judge John Judge's stream in just a second as soon as we have it. But I do want to talk about this weird Tinder date too, you guys. So let me grab that. Okay, so can you guys see that okay? All right, so this woman went on a Tinder date with Bryan Kohberger. She said he kept trying to touch me. She said that she went to the movies with him after being matched with him on the dating app. That's the Tinder app. And she said that, and this was in a TikTok video, which I'm not going to share, but she said that she posted on Monday and it has been viewed more than 1 million times. So that's a lot. She said that, quote, we matched on Tinder. We talked for a couple of hours and he was like, hey, do you want to go to the movies with me tonight? And I was like, sure. So we went to the movies. So this date took place 7 years ago, but she said her contact with BK was very brief, lasting no more than 24 hours. So she said she did not recall what movie that she went to, but remember that she and BK ended up in her college dormitory after the movie was over. She said that he invited himself inside and wanted to watch another movie on Netflix. She said he kept trying to touch me, not inappropriately, just trying to tickle and like rub my shoulders and stuff. And I was like, why are you touching me? Or what are you doing? So obviously she was uncomfortable. And then she said that BK got super serious. He's like, I'm not, and I'm like, you are. And he's like, I'm not touching you. Kind of like trying to gaslight me into thinking he didn't touch me, which she describes as weird. She then says that she then told BK she was going into a shared bathroom in her dorm and that he followed her there. I don't know about you. This is why if you're going out with somebody the first time, you probably don't want to have them back to your place. But that's just me. He didn't go in with me, but he like stood outside the door and like, I don't know. I just thought that was weird. So she was uncomfortable. She was uncomfortable. In an effort to get him to leave, she pretended to throw up, but not because she was afraid of him. She wasn't afraid of him. She said, it wasn't because I was scared of him or like I thought he would hurt me if I asked him to leave. It was just mostly because I'm socially awkward. I didn't know how to ask him to leave. She said he then sent her a message on Tinder as he was leaving. He said, awesome, my plan worked. And then about an hour after that, he texted me and said, I had good birthing hips. That's just weird. And so she never talked to him again. That's like something you probably don't want to say to a woman on the first date. You have good birthing hips. That's just kind of odd. So I don't know. What do you guys think about that? I am watching for the thing to start. I didn't forget about you guys. Let me check in with chat though while we're waiting. So he told her she had good birthing hips. It was a creepy date. And just says it was a creepy date. Yeah. Leslie says, seems like guilt to me. I never heard this before. That's why I wanted to talk about some stuff before we got started. I thought it'd be nice to do a pre-show together and then we'll watch the hearing together. And I'm not going to be talking during the hearing. So you guys can hear it. Super weird. Holly says, wow. JJ says, me too. First date should be platonic. I just think, probably having somebody back to your house the first date, I just wouldn't do it. Even if you're in a dorm with a bunch of people, I would just be careful. Just because you don't really know who, especially if it's somebody you met through family or a friend, you're safer. But if it's just somebody you met on an app, you really don't know their background yet. You don't know if they have a criminal history. You just don't know if you're safe or not. Holly says he has no boundaries. Leslie says scary. JJ says no one should expect physical contact unless offered as such a hug or a kiss, maybe. And maybe that was just his way of trying to, engage with her. It doesn't mean, anything bad. Lori describes it as odd. Amelia describes it as socially inept. Pam says, I remember being tickled in about 7th grade. I think this speaks to emotional immaturity. Yeah, it could be. Lack of social skills. It's 9:50 a.m. in New Zealand. Oh my gosh. And then John says, that isn't right. And hello from South Africa. Yeah, tell me where you're from, guys. Brenda Barton says there's no volume on my end. You guys should have volume now. Try turning up your thing. My mic is on. So you guys should be able to hear me okay. All right, so I am watching. We are going to go to this in just a second, but I do want to just share a couple of things with you guys. That this we're doing a pre-show. Had to be run by the person who did the crime, was very lucky at guesses, or by law enforcement trying to interact with the person who did the crime. But I do believe this goes back to BK because this is what law enforcement believes. And we all know it's not unusual for perpetrators to insert themselves into cases such as this. Now, this account on Facebook posted regularly and then stopped right after BK was arrested. So again, this was either BK posting or law enforcement trying to dangle a little bit of bait to engage with the perpetrator. What do you think? Do you think it was BK? Or do you think it was law enforcement? Let me know what you think in the comment section below. So some people think that it was like him trying to post a little bit of bait. Like law enforcement just sort of dangling some bait to see if they could engage because it was being posted on Reddit and on Facebook. But it's not uncommon for people, for SKs and potential SKs to insert themselves into the case. We know with Dennis Rader, who was the BTK perpetrator, he was literally taunting law enforcement, and that's ultimately how they got him. So we've got UK. Welcome, you guys. Buffalo's, New York is in the house. Thanks, Joe. Leslie says safety first is what I told my daughters. Yeah, I think that's good advice. Louise, then it's on your end, honey. You're going to have to fix your sound because everybody else can hear me, okay? Billy says, I think they need to get on with his punishment. Well, he's not found guilty yet. He does get his day in court. So the jury has to decide. And all Ann Taylor needs is one juror. Hey, One Way Street. Thank you. Oregon. Jesse says hello. Hey, Judy. Holly says we have audio here. Please refresh if you cannot hear. All right. And Annette just became a member. If you want to join the Reporter Room family, you just hit the join button and your name will show up on all of our live streams and videos that we do. And I have a new video coming out tomorrow on this case. So I am watching my time. We've got just a couple minutes before this starts and we're doing a pre-show. I can turn it up a little bit. There we go. Hey, Jan, it says it's terrible our children are subjected to these predators. I agree. All right, so I am watching. I have not seen anything come up on this. Just waiting for him to post, and then we will pick it up. But I just want you guys to know I am here. So let's continue on with some of the information. I'm going to talk about the roommates and the fact that, yes, they were texting each other. So they were awake and texting. Now, the article that posted this also said at the end, quote, we cannot confirm if this information is true due to the gag order. So I'm going to give it to you with that caveat. This is one of the few things that I've seen where the article actually says we can't confirm this. So it is possible that they were awake and texting, but it could have been something mundane, like Xana and Ethan are having an argument. It sounds like Xana's crying. Should we check on her? But then, maybe, oh no, because Ethan's here, we don't want to barge in on our roommates, or maybe just complaining, that Murphy the dog was barking and playing around up with Kaylee, who knows? But as I shared with you last week, Jodi Arias and Travis Alexander, Travis's roommates, he had roommates, and he was done away with in a very graphic way. I'm watching my words. And the crime scene had lots of blood, and he was in there for days, and the roommates didn't know what had happened to him. And we know the roommates didn't do it. So why didn't the roommates call 911 or take more action at the time? Well, it's called the bystander effect. And so according to Psychology Today, if you think about that case back in 1964 of Kitty Genovese, this was in New York City. She was done away with using a knife outside her apartment. And at the time, it was reported that dozens of neighbors heard what happened and none of them called the police. So some psychologists named Bibb Latane and John Darley looked into it, and they came up with a theory called the bystander effect, which is a diffusion of responsibility and social media influence. So to just break that down a little bit, what they mean by that is that the diffusion of responsibility would mean that onlookers are there, but it's less personal responsibility if there are other people there. So in this case, because Dylan was the youngest roommate, she may have just been looking to see if, what her older roommates would do, would take some action. Was Kaylee going to, take any action? Was Maddie the ones who had been living in the house longer than her? She was the newest roommate. And then social influence means that how individuals monitor the behavior of those around them. So it could be that Dylan and Bethany checked in with themselves. Neither one found this particularly alarming. the noises that they were hearing, because this was a party house. Seeing a strange man in a house full of 5 young, many of them single women, would not have been that unusual, right? So it could just be that, they checked in with each other using the bystander effect and determined that it was okay and went to sleep. So I hope that that answers that question. Okay, so I'm going to go ahead and click over. Let me grab this because we should be getting started with Judge John Judge any minute now. Just waiting for him to post up his thing. And I'm so glad you guys have joined me to watch with me today. So nice to have you here. If you haven't subscribed, please do like, share, and leave a comment. So we're just waiting for this. And I am going to stream the trial so we can watch together as a community. So I'm just waiting for him to get started. It's supposed to start at 4, which should be in just a couple minutes. Angela G says, I have no doubt BK would have kept doing this if not caught. He wanted to be a major SK notoriety. Interesting. Jesse says, thank you, Jesse. I hit the like. High Pistis campaign says, when is the hearing? It's in 2 minutes. I'm literally waiting for the judge to post the feed so we can grab it. So we're here just watching together. I just wanted to do a little bit of a pre-show, but it should be starting in just a few minutes. Hey, I'm glad you're here. Thank you so much. That means a lot. Really appreciate that. Thank you, Louise. And Amelia says, psychopaths are organized, sociopaths are disorganized. Interesting. Hey, my missing piece. Good to see you guys. Jesse says courts do take a few minutes to start, and we're ready. As soon as he posts it, I'm ready to go with that. Thank you so much, Leslie. Amy says, I don't know why you can't hear me, Amy, but it's on your end, okay? Because everybody else can hear. So you'll need to figure that out. I don't know. If they do a change of venue, does Judge John Judge stay on the bench? Yeah, he would just go with the trial. No, I was not blaming the young woman. I just don't think it's a good idea to have somebody back to your house, but that's not blaming her. I'm not blaming her, just to be clear. Jasmine says, if they do a change of venue, does Judge John Judge stay on the bench? Yes, he does. Michael says, hello. My maker says, BK is wackadoodle. Lily says, way to act self-righteous. I don't know what you're talking. A long time sub here. First live. I love the channel. Thank you. Jack Johnstone says, glad to catch you on the pre-show. Thank you so much. And we're just waiting for Judge John Judge to get started. We are there. We are there. We are ready to go. We're just waiting on the judge. He'll be posting the feed, and then we will go to that. JJ says, very much in action, sixth sense, but can be both organized and disorganized. My understanding of the difference between is psychopaths are born and sociopaths are created. That's how I've always had it described. But that doesn't mean that I'm right and somebody else is wrong. That's just how I've always heard it. My missing piece says, YouTube didn't notify me. I'm catching it here in the UK. Don't normally catch a live. Okay. Check your volume on your phone or your TV. Yep, that's good advice, guys. I can boost the volume when we get started also. Chat seems a little glitchy today. Thank you for supporting. Thank you. Marilyn says she wears headphones every night. Maybe one or both of the roommates was wearing headphones and really didn't hear everything that was going on. Krista says she got home, have to start from the beginning. Louise says I refreshed my phone and the audio resumed. So yeah, if you guys are having audio issues at this point, it's on your end. I did have a little issue on my end much earlier when I first got started, but everybody can hear me fine. Sociopaths can be organized, just doesn't fit into social situations. Okay, so we're just waiting for Judge John Judge to get started and bring us his feed, and there we are. You can see BK sitting at the table with 3. That's as close as the judge is going to let us get to look.
Okay. All right. Sorry for the delay. We are now on the record. This is State versus Bryan Kohberger, CR 29222805. Mr. Kohberger is here in the courtroom. He is represented by Ms. Taylor and Ms. Nassif. Mr. Logston is participating through Zoom. The state is represented by Bill Thompson, Ashley Jennings, Jeff Nye, and Ingrid Beatty. The proceedings, I think they are live streaming through the court's YouTube channel. So please do not attempt to record, film, or transmit during the proceedings. Thank you for that. All right, so we have some motions to address today. And I thought we should first go with the defendant's motion to allow experts and investigators access to view IGG information. If that makes sense. I think also the motion to clarify sealed order for disclosure of IGG and merges into that. So go ahead, Ms. Taylor.
Thank you. You're reading the state's response. I think the state has no objection to the 3 named experts having access to the sealed IGG materials or the materials subject to protective order. So I think what we're really talking about is our investigative team for Bryan's case to have access to the IGG materials. And the state has objected to that. They've objected in part because they are not named in our motion. So I want to address that first. Your Honor, they are not named, and I can name them, that's not a problem. But the reason I didn't is based on consistency. These same investigators have had access to the grand jury materials to assist us in the case. They've had access to other things subject to protective order, and they're not named in those. They have access, there's 3 items subject to other protective order, and that's medical information from hospitals, that's University of Idaho records, and most recently, police procedures. They haven't been required to be named in orders in any of those. And so for consistency, I did the same thing. But we can name them if that is a sticking point. I would note that the members of the FBI that did the analysis are not named in the materials either. Your Honor, the reason why our investigators are important to have access to the IGG materials is because of the kind of case this is and the kind of investigation that we're required to launch in the case. We have to have investigators on a death penalty case, and we have them. These materials or these items in the IGG binder, those are things that we may end up filing motions in court for. In order to prepare for those, we rely on our investigators to help us with side tasks, with big tasks, with all of the tasks. We would need to utilize our experts. If our investigators can't have access to the materials, they'll have to be shut out of those meetings with those experts, and they'll have to be shut out of court proceedings that we might launch related to those materials. Your Honor, to meet our constitutional duties, in Bryan's case, his rights to have effective assistance of counsel, to have a full investigation, to have a fair trial, we have to have investigators. Those investigators are on board and have been on board, and they help us understand things that are given to us by the state. They help us find witnesses, they help us find experts, and they're necessary to be part of the conversation of what the IGG materials are and what they mean. This matters in figuring out how Mr. Kohberger ends up on the police radar and subject to these proceedings here. I know we've talked about this before, and I still don't have all of those answers. I believe today, with our experts getting access, we're going to make some headway with that, but we also need our investigators to be part of those discussions as well. Again, Your Honor, if their names appearing in a court order is an issue, that we'll do that. We'll do that. That's inconsistent with the other protective orders, but we'll do that. And they'll be subject to the protective order just like we are, and they'll abide by it just like they've done for the other protected materials they've had access to. And while we're on that line, if the court wants me to talk about the clarification, I can do that.
Let's hear from the state first. I mean, I understand the having investigators. I think what we're talking about though is just with the IGG that we have to be especially careful about, you know, who's going to have the access, what they're going to do with it. I think I agree. It's clear that the state has no objection to the three experts that you've named. So I don't think that's a problem. But let me go to Ms. Jennings. Okay.
Yes, Your Honor.
Thank you.
That's correct, Your Honor. And Your Honor is familiar and aware of the materials that we're discussing, and you're also aware of the sensitive nature of those materials. The state is really just following the court's lead in your protective order, where you named specifically who on the defense team would be allowed to have access. It follows that if we're going to expand that access, that those individuals need to be specifically named. And it's really going to be the only way the court can have control of any unauthorized dissemination, is to know exactly who was privy to what was enclosed. So at a bare minimum, we need to know who it's going to be given over to. Your December 29th sealed order also said that any further dissemination of the materials or the information contained within the materials, including to any investigator or experts, must be approved by the court after a showing by the defense as to why such individual needs the information. In the defense's motion, their stated reasoning is, quote, to investigate how and when Mr. Kohberger was identified as a suspect, end quote. State maintains they don't need access to all of that highly sensitive information. To satisfy that purpose that is laid out in the November 28, 2023 letter from the FBI to the state. So we would ask that one, they be named. If they are granted access, that it be to that letter, and that the balance of the materials be protected. And we would ask that you follow the proposed language in the state's response from February 9th to ensure further protections of the materials.
Thank you, Ms. Jennings. Sailor?
Well, Your Honor, I know what letter Ms. Jennings refers to, and I think our experts should have access to the actual materials. That letter is a summary. It's a police summary. Our duty is to investigate police work. We do that in every case, and with our heightened duties in a death penalty case, our investigators should have access to the entire record. Our investigators understand what a protective order is, and they'll abide by that protective order. Again, if you want them named in any order allowing them access, that's fine. That's just fine with me. It's most important that they have access to all of the materials. The summary contained in the FBI's letter isn't the totality of the materials. It doesn't show some of the particulars about things that were happening on certain dates. And that's what's important to put into a timeline so that we can try to understand how the state did its work in this case.
Well, one of the issues with this IGP is relevance at all. And so the way I'm viewing it is maybe it needs to go on steps, maybe where it's justified with the relevance or the potential of relevance for some of that information, because from the very beginning, the state's position has been it has no bearing on the case. It will not have any bearing on trial. But I allowed the access to what I thought was potentially relevant, and to allow your experts, now allowing your experts to view that information. So let me just kind of move into the other clarification, because I also understand, particularly relevance of mitigation. Okay, what your investigators need to cover. They likely have to have contact with Mr. Kohberger's family, and that we're not, I don't think we're talking about that kind of investigation. I mean, that is your responsibility. It's also your responsibility to dig in wherever you have to. I mean, I think you're required to do that. So my balancing responsibility is to keep it in control to some degree. So I guess what I'm asking is that I have some justification for making contact with certain families that may have no bearing whatsoever on the case, unless it's in mitigation or something like that. Now, the DNA issues, especially, I mean, maybe especially in the IgG, it has to have some relevance if there's some context, okay, that connects to the case itself. That's how I'm looking at it. I might be wrong, but so you can respond. Okay.
All right, we're talking about a couple of different things here. With our request for clarification, I was talking specifically about people that are already known to our team that we may be in contact with, Bryan's direct family, parents, sisters, aunts and uncles.
And
Those
can I interrupt you just for 1
Sure.
second? That has no relevance to the IgG information that you were given.
those are people we already knew before.
Okay.
So I want clarification that I can continue to talk to the Kohberger family.
Yes.
I want to make sure I'm not running afoul of court order.
think
and I
that's
wanna be-
absolutely appropriate.
I want to be really clear who I'm asking for to have access to the IgGs. It's not our mitigation investigator. That our mitigation investigator, I think the court heard me talk about going 3 generations back to do her work. That's required under the ADA. I'm not talking about her. She wouldn't have access to this. I'm talking about our criminal investigators dealing with the innocent space for Bryan. Those are the people that I think should have access to the same materials under the same protective order. They're not doing the generations back. None of the IgG materials would be used for that part of the mitigation work. She's doing her own thing, our mitigation investigator, looking backwards as she's supposed to at the things she needs to. That's not the IgG materials. So putting aside that investigator and thinking of only our criminal investigators that are going to be dealing with our innocence phase of the case. Those are the investigators that I'd like to have access. They're the investigators that participate in the meeting with our experts. They're the investigators that help us put the timeline together to understand different things that were happening in the case before Bryan's name was ever spoken by anybody. And we're missing that big piece about why was Bryan's name spoken and how does that connect to the other pieces that we have. That's what our criminal investigators are going to do. They're not looking at IGG materials, if allowed, to do any of the mitigation work. That's separate and apart. So I want to make sure that that's really clear. Also, when we're talking about whether something is relevant or not, I think that we're thinking of the standard for information to come out in court. That's not what I'm talking about. The court found that the IGG information was material under the discovery rules to the defense and allowed us to have access to some. It's for that same purpose and under that same rule that we're asking the court to allow our investigators to have access to the same materials. Whether or not any of this is something that comes into the court or into trial, that's a question to be answered later. I can see how, I think, this is why I'm really happy to have our experts involved, but I can see a way that there may be a motion practice that happens that relates to this. I'm not there yet.
That's where I'm because if you have these experts, okay, go through this. I've been through all this information, and so if you can go, using your experts, and your experts kind of can tell me and state that you need to investigate particular people, okay, that were involved in this, then we can have a hearing about it. But I'm not quite ready to be convinced that without getting this information from the experts that we're gonna find some pathway, okay, that's going to be helpful to Mr. Kohberger.
I mean, this is
I don't know.
courtroom, so if that's what you want to do, we can. I'm here. We waited a while to come to this hearing. I'm asking for it all with a protective order. If we do it the other way, we can do it. It's just everything takes time. And if that's the preference, that's okay. The court knows and would order us to not reach out to any of the people in this material, and we wouldn't do any of that. If we have a motion to file that references any of the content of the materials, that would be filed under seal. These are sealed items. If there was a hearing, I would guess the court would have a chance to look at the filings before granting me a hearing and hear from the state, and that would be sealed. I'm not asking our investigators have access to run out and start interviewing people. I'm asking they have access to not be shut out of conversations, considering what this means and how our client came to the attention of law enforcement, and to plug things into the timeline of us trying to understand how we got from November 13th to December 29th. That's it, not to go out and try to talk to people. I can just see that there's a potential motion to be filed, but that wouldn't be contacting anybody at all. That would be a motion for the court.
That's reassuring. I mean, that's one of the concerns. I mean, pulling a lot of other people into the case that, are completely innocent and don't even have any connection to the situation. So let me go back to Ms. Jennings. Do you have any response to any of this?
No, Your Honor, I'll just reiterate that Ms. Taylor keeps discussing their ability to just understand the timeline. Again, you're very familiar with the materials. Understanding the timeline and how we got from November 13th to December 29th is all laid out in that letter. None of the other materials are going to answer their questions regarding the timeline. So ask that they be given access to that, named investigators, to that letter.
Thank you. you may remember a few hearings in the past that the state from the very beginning said there was no, that played no no, I don't know how to even, it wasn't, when I asked them in the hearing, that did you use the IDG, any of the information at the IDG to get the warrant, to get Mr. Kohberger's DNA, that was not part of it. So in terms of the time frame, don't know that it's that complicated, because a lot of what happened in the time frame happened before that. Now, that's up to you to dig into that, obviously, but there was a lot of information in the letter too, just their sequence of using the IgG at all. So we're going to have to sort this out, obviously. But going back to what I'd like to do is just get some justification for digging in deeper, if necessary. And I'm not sure it's necessary, but you know, I'm going to keep an open mind about that. So for right now, I would say, let's just get your experts looking at the IgG stuff and exactly what they can read from that. And we'll go from there. Okay. Now, with regard to your clarification, yeah, I mean, I'm not saying that your investigators can't contact people that they've already contacted without relying on the IgG information. That work for now?
Yes, Your Honor. Our mitigation expert has done her own family tree based on her work, and she has nothing to do with the IgG material. She's not an expert that would have access to that. She's not named. So she needs to keep doing what she's doing as far as her work goes. And I think the proper clarification is that the IgG materials will not be used to develop any investigative leads.
I think that's fair. And what Ms. Jennings proposed in language in their response to your motion, is that something that you would object to at this point? I'm sure you probably read that language.
I did read it. It's a little bit less straightforward, but I think it covers it. It allows me to continue to speak to the people I'm speaking to and that I need to speak to that are on my list.
Okay. Anything else about that?
No.
These issues. Okay. Ms. Jennings?
No.
Okay, great. Okay, the next question I had is, I know that Mr. Kohberger filed for permissive appeal to the Supreme Court. And I just wondered what you know about that, because I have heard nothing about that. I know it was filed.
I know the states filed their objection, and that's the last that I recall seeing about it.
Yes. So at this point, we don't know if the Supreme Court is going to take it. Okay, we don't know that. You know anything else, Mr. Thompson?
Not other than the state's response was filed by the appellate division of the Attorney General's office. And I think we're just waiting to hear from the Supreme Court at this point.
Correct, Your Honor. We're just waiting to hear from the Supreme Court. I can tell you there's no deadline in the rule for them. They didn't include a deadline for themselves. And in my experience, it can take anywhere from a couple weeks to a month or so. So at this point, we're just waiting to hear.
So I don't know the answer to this. If it's filed, does that pause what we need to do here, or do we just pause it only when they pick it up?
My read of the rules, Your Honor, is the latter, that we continue as we are, unless and until they decide to take it. And then they would decide at that point what exactly is paused and not paused.
Okay, thank you. Anything else about that, Ms. Taylor,
No, thank you, Chair.
Mr. Thompson?
No, sir.
All right, I think we're now to schedule. Starting with, there was a request on change of venue, maybe late April, you were saying.
Yes, Your Honor, either that last week of April, I think it starts the 29th and 30th, or the first or second week of May for the actual hearing is when we'd request. And we would ask that we have until maybe the second week of April to get our initial briefing in, and then the state's response and our reply after that.
So what are you thinking would be the hearing? Give me a day or a week.
I would say that first full week of May, maybe that's May 5th or May 6th.
All right, thank you. Okay. Ms. Beatty, Ben? Right?
Your Honor, we're asking the court to either deny this motion for change of venue as premature or to set a hearing date closer to the trial date when that trial date gets set. And the reason for that is when courts look to change of venue and whether or not that's appropriate, the courts look to affidavits that have been filed. Importantly, they look to what jurors say, prospective jurors say during the voir dire process. Another thing that courts look to is the amount of media coverage and the proximity of that media coverage and the intensity of that media coverage to the trial. So in this case, I think we don't have sufficient information to even determine whether or not that's appropriate without seeing what prospective jurors actually say. But B, we're far enough out from trial that we can't really gauge that anyway. So we would ask the court to either deny that motion at this time or to set a hearing further down the road and closer to trial. If we do proceed to hearing, the state would just ask for a scheduling order. At this point, the defense has filed a motion. They did not file any affidavits, disclose any experts. They haven't even filed a supporting memorandum. And so we're not even sure what specific cases they're relying upon. So we can't really respond substantively to that motion until it's briefed. So we would ask the court to set a briefing schedule as well. Thank you, Your Honor.
Okay, thank you. Well, my interpretation was that they were going to give us a lot of information, affidavits, maybe testimony for the hearing. Is that right, Ms. Taylor?
Your Honor, you're right. The motion was to put everybody on notice that we'd like to have this addressed. We do intend to have a presentation for the court. We do intend to have briefing for the state. I anticipated we'd get that scheduled today. But no, I didn't file the motion. I filed it to put everybody on notice that it's coming, and I think we need to address it. I think we need to address it before a trial setting. It doesn't make sense to set a trial, get right up to it, and then have to have everybody who's under subpoena rescheduled and have to have the public and the families of everybody disappointed because we're going to reset it at the last minute. So I think we should take care of whether or not the court should change venue sooner rather than later, especially given the length that this trial is anticipated to go. We'll need to schedule a courtroom either here or in another county in Idaho. I mean, we'll need some advance notice to get that done because it'll take a long time to try this case.
Thank you, Ms. Taylor. Thank you, Ms. Beatty.
And Your Honor, the state is asking for a briefing schedule so that we're not in a situation where the state is learning for the first time during a hearing what experts the defendant might be calling and what their arguments are. We would ask that all of that information be disclosed prior to hearing, including the CVs of any experts that will be testifying.
Well, that's certainly what I would expect. But it's quite sticky, right? To think, you're going to wait until ready to seating the jury, which is probably a 2-week process in this case. And then figure out, hey, we can't see the jury, so we have to move the trial. At the same time, how do you really know if there's some prejudice without trying to see the jury? It's really a catch-22.
And all of the logistical concerns that Ms. Taylor is describing are totally correct. The problem is that is what the law requires, and that is what the case law says. The case law does contemplate that. So certainly it's correct to note that there are going to be logistical challenges to that, but that's what the case law requires. But even if the court weren't inclined to wait until we're actually going through the voir dire process, at a minimum, I think it would be appropriate for the court to look to some jury questionnaires and at least go through that process.
Okay. This morning I was looking at State versus Haddon, where that was, you're probably very familiar with that, but that's Court of Appeals case, 2012, I believe. And there was a request to change venue well before the trial. The judge denied that, and then it came up again when they were trying to seat the jury, and then the judge denied that at that point. But kind of a double step to figure out if it was necessary. I've been struggling with this, for 12 months. And so it's hard to know. Now, that doesn't mean that one of the parties can't present evidence. And the standard is kind of squishy, in my opinion, but they can provide that kind of information well before the trial. At the same time, I want to make sure that the state has the opportunity to respond to whatever information Mr. Kohberger is going to present. So now I'm scratching my head about, is May, first week of May, does that allow enough time? Does that allow enough time for you, Ms. Taylor?
Your Honor, I think it does. I can present the information to the state. I can have my briefing and I can have affidavits and let them know of any witness that I want to call. I can do that probably by the beginning of the second week of April. And that would give them, if we do this in May, that would give them ample time to read it over and respond to what we intend to present.
Thank you. Ms. Beatty, what are your thoughts?
Your Honor, as far as the duration of time between the briefing and the hearing, the state has no concerns about that. The state would just have concerns about those factors that the courts require us to look to as far as the timing of the hearing compared to the timing of trial. But as far as a briefing schedule prior to the hearing itself, that timeline makes sense to the state.
Well, let's explore that just for a moment. Because I've been thinking about setting a trial, also for months, but I listened very carefully to Ms. Taylor and Mr. Thompson in our last hearing, and I really, it wasn't clear that I'm not really happy about setting the trial in 2025. It seems so far away. Now, it's not just, doesn't just affect Mr. Kohberger and his defense, but there's a lot of other considerations. So I am trying to be fair and realistic, okay, about when we could really be ready for trial. Now we want to do it once, okay? So let me go first to you, Mr. Thompson, about when. I know that it's been complicated, the discovery. I mean, you have these different agencies, FBI, state police, the state lab, We've got Moscow Police Department, Latah County, Pullman Law Enforcement, Pennsylvania law enforcement. And I think you mentioned it's hard to get all this stuff together. And that is one of the things that has delayed setting the trial. Not to mention the motions about the grand jury procedures, also the issues about the investigative genetic genealogy issues. And I'm kind of curious, okay, when do you think that you will be completely finished with providing discovery to the defense?
Judge, most current projection that we have would probably be at the end of this summer. The majority of the discovery has been provided. That's not to say that Mr. Kohberger has been able to, and his defense team been able to digest it all, because it is substantial as an understatement. We are still awaiting information that the defense both wants and needs to have, and we're going back through all of the discovery to make sure that nothing's been overlooked. We have 2 members of our team, an attorney and a legal assistant, who are essentially assigned full time to that task. And that's projecting we got from them. It could be up to 6 months, which would put us with initial discovery completion at the end of August, 1st of September of this year.
Because last time you were talking about August for the trial.
Sure enough. And that's what we had hoped for. And when we filed our motion for trial setting scheduler back in December, a couple months ago, we felt that was realistic. And as we are looking at where we are right now, I'm not sure that it is. We know that the defense has already indicated that just on the death penalty alone, they will be filing multiple motions, and many of them very lengthy. We've seen the same filings in the Nez Perce County homicide case that recently resolved. Those I could see taking a couple months in and of themselves to address, in addition to motions that actually directly relate to the merits of this trial, discovery, motions of limine, and that sort of thing. Our team met again this morning with our companions from the AG's office here in Moscow, and we actually have a proposal to make to the court for a trial date and a scheduling order, if Your Honor is interested.
I'm very interested. I'll tell you before you say anything about that.
Yes,
I was looking at whether or not it was realistic and fair. Okay, trying to be compromising to some degree. I think it was March 3rd. 2025.
Well, Your Honor, it just happens to be in pink highlight on my ad here, March 3rd, 2025 for trial.
Okay, I had no idea. I wasn't reading your mind or anything, but I thought that's about the mid. And I remember, Ms. Taylor, that you said that would be the soonest you could be ready.
And that was if everything went right from that point.
And I remember that.
And
too.
it hasn't. It hasn't. But I'll hear what their proposals are.
Okay. Go ahead, Mr. Thompson.
Thank you, Judge. So we would propose that the court set March 3rd of 2025 as the start of trial. We would propose a September 6th, 2024 preliminary discovery deadline that would include exhibits known at that time. November 8th, 2024 for the defendant's discovery deadline that would give them a chance to respond to any last minute discovery that comes out from the state. February 7th of 2025 for the state to disclose any basically reply or rebuttal to what we've learned from the defense discovery. That would include rebuttal experts. The defense's deadline would also necessarily have to include their mitigation evidence. We would suggest the court consider a final pretrial conference, kind of the pretrial wrap-up details conference for the week of February 12th to 16th, 2025. Since the death penalty related motions are already known and they aren't dependent on discovery, we would ask that any death penalty related motions defense have be filed by September 6th of this year, that the state have until October 11th to respond. The defense can then reply by October 25th and schedule a hearing during the week of November 4th through the 8th of this year. So we can get that wad of 12, 18, however many of those motions are going to be filed, we can get that handled. We would suggest that the court direct the jury questionnaires, if we can't agree on one, that the record suggestions from the state and the defense be to the court by November 1st of this year. That would give the court the opportunity to finalize a jury questionnaire that the court is comfortable with, and it can be ready at the start of the next calendar year, which is when the next jury pool would be polled or would be drawn. And the court can, at that point, get questionnaires out to an initial panel and can assess in a timely fashion, are we really going to have venue issues in the early part of next year as we approach March 3rd. We propose the jury instructions exhibit list be exchanged by January 31st of 2025. And finally, as to pretrial motions, which would be case-specific motions in limine and those sorts of things, the deadline for filing, that would be November 22nd of this year, with the understanding that parties could file them early. I mean, the state already has been developing a list of various pretrial motions in limine that we think we'd like the court to consider, and we can file those early. But the deadline would be November 22nd, responses by December 13th, replies by December 20th, and then schedule a hearing on any of those pretrial motions sometime during the week of January 6th through the 10th. And I think
You have to write that down.
I have it all written down.
Sorry.
Yes, sir. And we can get it to you in writing. That's not a problem.
Okay. Ms. Taylor, so if things aren't going perfectly, of course they never do.
They never do, Judge. They never do. And I'll say it again. Death is different. This is a capital case. I've heard the court say the court only wants to do it once. I've heard the court ask, what can I do to speed things up? I need discovery. I need all of the discovery. I need the things that we've asked for. I need to not have to fight in motions to compel for things that was done on behalf of the state by the FBI that ends up being used against Bryan or used in the investigation. I need that stuff. I need, when I ask for something, I need to get it rather than have to go back and ask and ask and ask again. And I'm not saying anything mean about Bill Thompson. I'm just not. I think he tries his very best, but I think he's hampered by the agencies and the information he gets from them. I can give you some examples. We asked for x-rays. We were told they don't exist. They're listed repeatedly in reports. We asked for them again. And I'm not sure if I'm getting them or not. The response is we have thumbnails, but we haven't found the actual x-rays. There's one example. I asked for certain mapping data done by a member of the CAS team. They said, you have it all. I said, no, I don't. I only have November 29th. And they said, oh, well, I guess we just didn't get that. Something didn't copy right. And I'm not saying anything mean about Bill or his office. I'm saying this is really difficult to drag the information out and get it to my experts or to understand it. And to hear that we're going to have a discovery deadline by the end of August is great. I need to have every piece of everything. I then have to have time to double check and make sure I really got it. I need to have time to get it to my experts and for them to have an opportunity to understand how that impacts their opinions, if at all. So I'm prepared for this case. And then we need time to get things to the state and for them to respond to what we send to them too. I know that this court wants to set this trial. These kinds of cases don't happen in a year. They don't happen in 2 years. They take a long time. This case is challenged with the way discovery has come at us. I'll give you another example. I open up, I get them and I list them in my computer by date. At one point, I gave the court a printout of that so the court could see how I'm getting it. And when I look in a folder, it has subfolders. And I might get some reports from Moscow Police Department with an FBI report. And an FBI report might reference an email. It might reference a photograph. It might reference a screenshot of a picture or of a phone that they took when they interviewed somebody. That's not with it. So maybe a few months later, I get some photos that has these screenshots in. And now I have to try to figure out who gave that screenshot, whose phone did that come from, which officer did that interview, and get them matched up and figure out if it's somebody I need to talk to. So not only do we have a huge volume of information, the way I get it is completely disorganized. And it's like if you wanted to play 52 card pickup with 100,000 decks of cards and throw them in the air, and I have to go figure out how to put them together. And by the way, the backs of every one of those cards look the same. That's what I'm doing. We also have science questions in this case. We have DNA, we have cell phone analysis, we have video analysis. The video analysis that the state really likes in this case, I don't have the full scope of that video with audio that should be available. They're working on it, they really are. I don't think they're not working on it. I'm just saying this is a real thing that takes time. And then you have the public nature of this case, and people don't want to talk to us. They're not wanting to talk to us. So we have to try to get witnesses, people that are listed in the state's discovery, to talk to us. We have our duties that are required with mitigation because there's no break. I don't get to go to trial on the innocence phase, and then if something goes wrong and Bryan's not acquitted, I don't get time to go prepare that mitigation. I have to take another breath and start right there. So I have to have time to do all of that. Our mitigation expert is working as quickly as she can. She is meeting a lot of resistance to collect records and to conduct interviews. We're working through that as best we can. She has travel obligations to try to interview people. These things take time. I want all the discovery by the end of August. I love the discovery deadline by September 6th. That does not allow me enough time to get ready for trial by March 3rd. That deadline, that cutoff for us to get mitigation materials, that's impossible. That's just impossible. We've got the year pretty well scheduled out with what travel still needs to happen and what records still need to be obtained. So to have that to the state, I think they said by September, October, that's just impossible. I would request that this court take up our venue motion in May, make a decision on venue, and let's see where we can get with the discovery. I still need to read every bit of discovery that's come, and I haven't. I scan it when I get it, but to go page by page and read it and understand what it means, I'm not through 2023. I have a long ways to go. So I don't think that is realistic to set it. I think if you set it for March, I'm going to be back here after the discovery deadline, and I'm going to be telling you there's no way that we're going to be ready for trial. I would rather this court set the change of venue, make that determination. Let's see where we get with the discovery by May. Probably the court would have a decision by the end of May, early June. Let's see where we are with discovery by then and set a realistic day. I hope we can go by summer of 2025.
Well, thank you, Ms. Taylor. I can help in any way to speed things with, if there's problems with discovery, I'm happy to do that on very short notice, just so that we can keep going. But you say, it'd be fantastic if you got all the discovery by August. Your mitigation person has been working already, right? And just to know that I'm not being insensitive about this, I did read the ABA supplementary guidelines for mitigation function of defense teams in death penalty cases, and it's huge. Okay, I get it. There are so many things that if you don't do, then it comes back as, well, you were ineffective. And those standards are high standards for sure. And it takes, obviously it takes a lot of time. So, but I'm also thinking, if you get all the discovery, if you can, assuming that, which may be inaccurate, for the end of August, you're saying that you wouldn't be able to respond to all of that, assuming that it's even earlier than that, that you could not be ready for the beginning of March 2025.
That's exactly what I'm saying. I'm saying I love that discovery deadline. Let's shoot for that. And I think that would help me make a June 2025 trial. I think once we have that discovery, and I agree, we can file the challenges to the death penalty earlier, but the challenges to some of the things that are going to be contained in discovery, those we need to see it all and see how it interplays. I can do some things early, but I may be coming back and asking the court to reconsider if it doesn't go our way and we found something that we didn't have. I think a discovery cutoff is great, and I think the court has to manage that discovery. If we finally are up to the eve of trial and there ends up being a whole new dump of discovery, then the court has to look at that discovery and understand, is it exculpatory? Is it something that we didn't have a chance to prepare for? It should be excluded. If it relates to anything to do with the death penalty portion of the case, then the court's going to be asked to strike the death penalty. I mean, the discovery deadline is critical in this case. So I love that. I love that. What that means, if I have all the discovery by the end of August this year, it means that there is a stopping point where I can know I have it all. So I can confidently get the motions filed. I can confidently tell my experts, this is it. This is the scope of what you have to do. And I can have some space to read it all and understand it and get ready for witnesses too. If the court makes that deadline, know that mitigation is not going to be done by then. But if the court makes that discovery deadline, and then we follow that with our motion practice, and then our deadlines for expert disclosures and whatever's going to come from that, and our mitigation, we should be in good shape by June of 2025 to try the case. If we have that discovery come up, I think that's a great idea.
Ms. Taylor, Mr. Thompson.
Trying to figure out where to start first. Yes, discovery is massive. Yes, there have been things that Mr. Kohberger has asked for that we've inquired, and we were initially told, no, you don't have that. And then we have gone back at the prompting of the defense saying, you sure? I mean, it ought to be there. And for example, x-rays for the autopsy. Well, we just got those. The first came in with thumbnails. In today's discovery, Ms. Taylor's going to have the full size, which we were able to obtain when we saw he gave us thumbnails. These are useless. Get us the real thing. And through the coroner's office, we were able to finally achieve that. According to Ms. Jennings, we are better than 95% complete on discovery. So we're getting close. There are some things that are outstanding. There are some issues with what information is actually available to us. We have given Mr. Kohberger everything that we haven't asked for a protective order on or had some sort of dispute about. And we've given it to them, and frankly, in the order it's come in, instead of waiting to try to package it together and give it to them in a different format, just because they want it as quickly as possible. And I appreciate that. And we're going to continue doing that. It's going to benefit to have deadlines for everybody to have to work for here. I don't think just setting a deadline for state's discovery does anything other productive other than that initial stage. So if we're going to set discovery deadlines, we need a state's discovery deadline. We need a defense discovery deadline within a reasonable time after that and a reasonable time before trial, because we're going to then have to investigate whatever the defense tells us they might be using. And then, of course, an opportunity after we see what the defense is proposing or is disclosing to rebut that in some fashion and give notice of that. So that package of 3 days are important. Pre-trial motion on the death penalty, I think that's important. We need deadlines, so just get it done and over with. And both teams can prioritize based on the timelines what needs to be done when. I don't know the first thing about what's going on with defense's mitigation. Apparently it's been going on for a while. It sounds like it's going to be massive. That's something that we just don't have any insight to. We think that our proposals are realistic. We appreciate the fact that something could happen where it turns out that they aren't realistic, that something happens and we have to revisit. And I think we need to be prepared to do that. I think the last thing that I want to touch on real quick is the proposal to set a state's discovery deadline and set hearings on the change of venue is inadequate. As we've indicated, change of venue under the law, that motion is premature. We need to be able to give the court the benefit of what impacts publicity, for example, is having on our actual jury pool. We know there's publicity. Everybody can agree. There's been massive publicity, not just in Latah County, but I see more about it in Boise or hear about it from other parts of the state than what we're seeing locally. And so the massive publicity, that's a red herring, realistically. There's publicity everywhere about this. The issue is whether the publicity and the nature of this case is such that we cannot pick a fair and impartial jury in this county. And of course, we know that just being aware of publicity about a case does not disqualify a juror. There has to be a showing that that publicity or whatever has impacted the juror to the point where that juror cannot sit in this box as a fair and impartial juror and make a decision based only on the evidence presented in this courtroom. That's the issue that Your Honor is going to have to decide on the change of venue question. And you can't do that based on a bunch of affidavits from experts who say, Judge, there's been a lot of publicity. That doesn't cut it. So I think just having a state's discovery deadline and trying to prematurely move forward with motion for change of venue is not the right approach. We think that the proposals that we've made are reasonable, understanding Ms. Hayward has concerns about whether she's going to be able to meet those. And I think there are enough stages in there that if that becomes a reality, there's the opportunity for us to discuss that. Like everybody here, we only want to do this once. We do not want to invite error that we can avoid. Thank you, sir.
Yeah, thank you, Mr. Thompson. Yes, I think you said maybe you're like 98% on.
But probably a little bit more than 95% is what Ms. Jennings just told me.
Okay. So if it's 95%, I mean, is it possible that it could be done before the end of August?
It's possible, and we aren't going to wait till the end of August to do anything. We will continue to disclose information as we receive it. I mean, that's not fair to the defense. That's not fair to anybody. Just sit on stuff and dump it. So we are hopeful that it'll be finished by then, but we don't want to have to face a deadline that we think there's a chance could be difficult to meet. And that's why we propose the early September date, which would be essentially 6 months from now.
September 6th, that's what you're saying?
Yes, sir.
Ms. Taylor, you said that would be fantastic.
That would be fantastic, Your Honor. And Your Honor can give us a January 2025 deadline if the court wants to set a discovery deadline for us too. Expert disclosures, I think maybe would take a little bit longer, maybe February 2025. The court gives us a deadline for expert disclosures. I want to comment on the motion for venue change. Your Honor, because I filed a motion and the court doesn't have affidavits or the briefing to understand how we're going to approach this doesn't make it untimely. I'm fully aware that the massive amount of media coverage by itself isn't all of it. But I'm also aware that this case has had more media coverage than most other cases, and it continues. So there is an impact of that. There are other considerations besides just the massive amount of media and an impact on potential jurors. That's what we're going to talk about. I think it's timely. I think it's appropriate to set a change of venue motion. I think it is what makes the most sense for the court to make that determination and set a trial date from there. If the court sets one here and has to change it later, a lot of things have gone into play to get that trial date set here, to get the courtroom reserved, and a lot of people realize waiting until the court has heard the information, more than affidavits saying there's mass amount of media coverage, the court can make that determination. If the court agrees to change venue at that time, then it makes a lot more sense to just set that trial from there. I would think by the end of, or by May, when we can have a hearing, I would think I would have a better handle maybe on the process the state's going through now with its discovery. I will continue to make the utmost effort to get all the way through every piece of what I have now and continue to follow up with questions to the state so that we can try to have this discovery issue put aside. Once we have the discovery completed, I think that we're going to have a lot better idea of what the motion practice is going to look like and how long that's going to take. And it'll be a more realistic way to disclose experts to one another with the materials that's required under Idaho Rule of Evidence 702. I think that's a better way to go, even though you might not set a trial date today, because at least you'll set one that's really informed that maybe everybody can rely on.
Thank you. Well, I want to make an informed decision about changing venue, and it makes sense to me. I mean, it may be premature, but I'd like to see what the defense has to say about that, what you're going to present. So, unless I'm just curious to hear this, I can always deny it. But if it's sufficiently strong and persuasive, then maybe it makes sense to do that. And obviously, when just for personal reasons, I don't particularly want to go to another county for 12 weeks, 13 weeks. Necessary. I mean, we'll do what we need to do, but I'm not, as I sit here, I'm not persuaded that we necessarily have to change it. I think that's an automatic. And there are a lot of factors, and that's one of the reasons why I was looking at this Academy case, which is that's court of appeals, but it goes through all of the other cases that have dealt in this issue. So I'm thinking, you said mid-April that you would be able to file all of your declarations, affidavits, whatever you're going to do. Let the state know that who is going to testify. If you're going to have witnesses to testify, there's going to be experts. We got a taste of that, sometime at the beginning of one of our hearings. So maybe I'll hear the same witness. I don't know, but so we'll say April 17th.
Yes, I can make
Okay.
that.
And maybe we say the state has enough time to have their response by May 1st. What do you think?
I think that's appropriate, Your Honor. Thank you.
Because there may be experts on the other side too. So, and I expect the information that you're going to present both sides and with a brief. So obviously. And I'm going to be in Boise the next week. We actually have other cases. This dries. How do you feel about afternoon of May 20th? That's a little far out, but we've already been talking about maybe having a trial starting in June. So
Your Honor, can I have it before May 25th? A witness I anticipate is not going to be available starting May 25th. Starting May 25th, I think, for 2 weeks. So if I could have it ahead of May 25th, that way we
we have
can.
a jury trial that week, May 20th. This afternoon of May 14, give you enough time, Ms. Beatty.
That was May 14th, Your Honor.
May 14, that's Tuesday.
Yes, Your Honor.
Okay, we'll say, how about 1:30?
Sounds great, Your Honor.
Okay, 1:30, May 14. I am going to make a determination about that presentation on change of venue before I set the trial. It could still be March 3rd, or maybe beginning of June. Yeah, that's 2024. I know. I'm just still thinking of 2024. But it's hard. It is hard for me to think it. It's so far out. But I'm listening carefully to both sides, and it's a complicated case, and it's a death penalty case, and that adds a lot of, it really does. So I'm gonna hold, I would like you to send me your scheduling list, and I will think about that. We're going to have a deadline of September 6th for discovery from the state. And Ms. Taylor, did you say beginning of January?
Yes.
Okay, January, give me a date.
9th.
9th, okay, good job. All right, and that'll be 2025. Ms. Beatty.
Could we address one more deadline briefly?
Yes, of course. You all give me deadlines. I'll write them down.
Thank you, Your Honor. There's been an ongoing discussion beginning most recently with the state's request for scheduling order, and I believe Ms. Taylor briefly addressed it at the last hearing. There's been an ongoing discussion about the alibi deadline, and the state is asking the court to either limit the defendant to presenting evidence about the disclosure that he made related to the alibi, which was that he was driving around the night of the homicides, but not allowing any further discussion or evidence of an alibi, given the amount of time that has passed since the state requested that alibi disclosure. Alternatively, since it was in the court's scheduling order initially prior to the trial getting vacated, we would ask the court to set a 10-day deadline now, because that is consistent with the alibi statute. The state does not believe it is appropriate to tie the alibi to the jury trial date in this case. The statute that sets forth that 10-day timeline is completely separate from Rule 16 and other discovery deadlines through the litigation process. I think at this point, there has been so much time that has passed, and it has frankly causes the state great alarm that the defense is discussing calling upwards of 400 witnesses during the innocence phase when we don't have, potentially don't have a full alibi disclosure. And when you look at cases regarding appeals from issues that arise during alibis that come up at trial. These cases are all defendants appealing a conviction because the state doesn't get a second chance. If the state gets ambushed at trial, that's it for us. We're asking the court to hold the defendant to a fair alibi deadline, and I think that the time has come. Thank you, Your Honor.
My understanding was that was it, but I may be wrong. Ms. Taylor.
No. When the court vacated the trial setting, the court vacated all of the deadlines, including the alibi deadline. That wasn't carved out as one that was still held through when the court vacated the rest of its scheduling order. So I don't think that we're foreclosed from that. The court also has the ability to give an extension besides the limited time by statute. In this case, it's more than Bryan was just driving around. We have let the state and the court know that we expect that will be supported by expert testimony and by cross-examination of the state's experts. I need their full cast report and the rest of the discovery related to that before I can say more about that. So to tie me to a deadline when I don't have the rest of the discovery that I've been waiting for that would relate to that will mean that I will be back asking the court to reopen it. My expert can't finish until I get the rest of the discovery as well.
And the discovery you're talking about is a video of the car?
No, I am.
What do you?
So the video that we talk about is one that I think the state's going to use in its case that I don't have full video on, that I'm not talking about any video of Bryan's car. When I'm talking about an alibi defense, unless there's video that shows it elsewhere that I haven't gotten to yet, which may be possible given the fact that there's a lot I haven't seen yet. What I'm talking about though is the cast report, the drive testing information.
Cast report meaning the identification of the particular car.
That is the cell tower information.
I'm with you.
So what that is going to show and what the drive testing data is going to show and what other reports related to that are going to be things that my expert needs to finish our investigation and things that I need to formulate my cross-examination against the state's expert. So when I'm telling you that I'm going to do those things in alibi, I can't tell you more than that right now, but that's how we're going to support Bryan's alibi, that he was out driving that night.
Okay, so you're saying that you have not received the cell tower reports?
I have some data, some cell tower data, some phone record data. I have a draft of a cast report. The most recent information I have cast is the FBI doing their work. The most recent information I have is that on March 31st, they expect for that report to be done through the peer review process. So I may get it a month from now. I need to get it to my expert to digest. There's materials that support their report that I don't have full disclosure of. And the state's aware of it. I think they're working on it. And maybe they're on that drive that I'll pick up today, but I haven't had them yet.
So you expect to get that in mid-March?
I expect to get their report after March 31st after it's done. The supporting data, I'm not sure when it's coming. They tell me it's coming.
Okay, I'm gonna kick it back to the state.
Your Honor, I guess I'm a little confused because if
I obviously am too. So
okay. I'm confused because if the defendant's alibi is that he was out driving around that night, I'm not sure what additional information his cell data could add to an actual alibi defense. It seems like what the defense is asking for, and they're being completely upfront about it, and I appreciate that. But what they're asking to do is essentially double check all the discovery before disclosing their alibi, and that's not what the purpose of an alibi deadline is. In fact, it's quite the opposite. There is case law that describes that given the ease with which an individual could fabricate an alibi, and certainly that's not what the state is accusing the defendant of doing. I'm using language that is in case law though. Given the ease with which an individual can fabricate an alibi, that is a very legitimate deadline. It's a reasonable deadline. It's a reasonable demand of the litigation process. There is a reason why there is a 10-day deadline in the statute, and that is because the defendant is able to tell his counsel where he was that night. They can work together and formulate a defense, and they can disclose an alibi. That is the whole purpose of an alibi deadline. The state has complied with the discovery up to this point. We will continue to comply with discovery. We are disclosing everything that we have to the defense when we get it, unless there's some protective order issue. We are asking that the court hold the defense to a fair standard that has been set forth in this statute and that is constitutional under the United States Constitution and the Idaho's Constitution, that has been repeatedly upheld by the United States Supreme Court and the Idaho Supreme Court. Thank you.
Okay, I maybe dropped the ball, but went through the cracks that I didn't. I guess what I interpreted that as that was it for what we were going to hear about where he was and how he was established, the evidence that he was in a particular place. So once again, trying to be compromising, I'm going to give you until April 17th. You can submit the other information that you need to find for then. And that should be plenty of time because you're going to get some additional information from FBI apparently by the end of March. And we can talk more about that later at the hearing on the motion for change of order. So that gives you some cushion. I'm not going to set it for 10 more days, but I understand that that's setting that. And the reason for that is so you don't have an ambush at the trial. I mean, that's why that is established as a law. Okay. Well, I think we've gotten somewhere. And is there anything else we need to address today, Mr. Thompson?
I don't believe so, Judge. Thank you.
Okay, Ms. Taylor?
No, Your Honor. Thank you.
Okay, great. Thank you all. We are adjourned.
Okay, guys. So, and I'm going to take this down because he's done. So no trial date was set. Ann Taylor got her way. She didn't want a trial date. She wanted the conversation to be all about a lot of evidence. She wanted the conversation to be all about, poor me, woe is me. Again, claiming the prosecution hasn't turned over everything, while at the same time saying that it was not their fault. But I think it's got to be really frustrating on the part of the prosecution to be sitting there while she delays. And she got everything she wanted. She didn't have to give the alibi. That 10-day, you're supposed to turn over your alibi to the prosecution within 10 days. The judge extended it by several months. She still didn't meet the deadline. And now here we are, months and months later, and the judge still gave her more time to go through everything that she wants, everything the prosecution has. She wants to know what if they can put him on CCTV camera. She wants all the footage before she tells the prosecution what the alibi is. But that's not the purpose of an alibi. The purpose of an alibi is so that we don't spend all this time going forward with all these hearings and motions if the defense can place him somewhere legitimate. It's not to allow the defendant to get all the information so he can then create an alibi that works well. But Ann Taylor got everything she wanted. She got the hearing, another hearing set up, so she didn't have to set a trial date. So no trial date was set. She got that. She won that. She got, still didn't provide an alibi. She got that. She got her discovery date that she wanted. So she got that. So it just seems I'm just really frustrated that we don't have a trial date because that should have been set today. There's no reason. It's for people that are saying, yeah, but we needed enough time. He was arrested on December 30th of 2022. the prosecution was willing to do March of 2025. That's 3 years and 2 months. 3 years and almost 3 months, depending on where in March they would have put it. But she doesn't want that. She won't agree to that either. So I think, it's really, really frustrating. But she still wants the narrative to be, woe is me, my poor underdog client can't get a fair shake because everyone's, manufacturing information against him. The FBI. So, her job is to give a vigorous defense. But I also think that the victims' families have rights here too. And I'm not saying that he doesn't have enough time, but since when is 3 years not enough time to prepare for a trial? That's plenty of time. No, it's 3 years because he was arrested December 30th of 2022. And we're talking about March of 2025, which the prosecution originally wanted summer of 2024. They met the defense halfway in March of 2025 because the defense wants summer of 2025, more than halfway. And the defense still said, no, we don't want that either. We just want another hearing to decide if we're going to do this or not. So I have to say that this has got to be so frustrating for Bill Thompson and the prosecution team, because since when is 3 years not enough time? But, BK's sitting in jail. He doesn't have to be in prison. So he's got his TV. This jail I shared with you, I showed you pictures of the interior jail in a video I did last week. If you didn't check that out, you might want to watch that. But I showed you the inside of the jail. He's in a jail with around 20 other prisoners. So very small. That's right next to, it's adjacent to the courthouse. He's getting his vegan food. He has his tablet. These are probably things he won't get in prison. And then the defense benefits by delaying because witnesses pass away, witnesses move away, witnesses' memories fade. So, in my opinion, 3 years is reasonable, more than reasonable on the prosecution's part. And they were offering March 3rd of 2025 today. And Ann Taylor said, no, that's still not enough time. And no, we still can't provide Bryan's alibi, even though they were supposed to give it months and months ago. There's a 10-day rule. Once prosecution turns over discovery, the defense has 10 days to provide it. That was done and dusted months ago. And Ann Taylor is now sitting here months and months after this 10-day time frame has passed, and she won another delay today. She still did not have to give Bryan Kohberger's alibi today. So I don't know. I think it's really, really frustrating to watch. Yeah, I agree. Yes, he does. Let's go through some of your comments. Let's see what you guys are saying in the chat, and let's discuss what we just sat through together, because that's the interesting part. So Mace wants to know, does BK have access to electronic devices? He's watching TV, and I think he has access to a tablet. He gets his vegan meals. He gets to come to court and wear a suit. Julie says jail having a cushy time. I don't know if it's like cushy, but it's definitely better than prison, which is where he's going next. If he doesn't get if he's found guilty. Dollar Sterling says, I'm not sure if this judge is forceful enough. I don't know. I think, the prosecution has to be pulling their hair out because they got everything that they wanted. The defense team got everything they wanted today. They got to have the discovery date put on the date that they wanted. They got to have the no date set for the trial. So she won that. So I don't know. It's really frustrating. Bravo Brees. Hey, Bravo Brees says, if the prosecution hasn't been sharing discovery with the defendant, Ann Taylor has justifiable concerns. The prosecution has turned over everything. What Ann Taylor, even she was saying, she wants stuff that the judge has already ruled she's not entitled to. That's what she wants. So I don't think it's really fair to say the prosecution, you can't say on the one hand, the prosecution has given me so much stuff that I need years and years, 4 years apparently, and a change of venue before I can provide an alibi for my client. You can't claim that and then at the same time say they don't have everything. The prosecution has turned over everything that they're required to the defense team. She just wants that to be the narrative because it's in BK's best interest to be painted as the underdog. People are known to root for the underdog. So I think the state gave a very reasonable date. They wanted the summer of 2024. And remember, it was the defense team that waived his right to a speedy trial. They waived it. The prosecution didn't waive it. So they said, well, we'll do, okay, you don't want to do summer of 2024. You can't be ready then, Ann Taylor and defense team. Okay, how about March 3rd of 2025? She's still, oh, no, we can't do that either. We need more time. Beach Life says, I agree. I think the law enforcement is very compromised. There's been no evidence of that. If you have some evidence where they have been compromised, where we have, for law enforcement to be compromised and to just say that as a blanket statement without any credible information or evidence, I think is really not responsible. I think that for law enforcement to have somehow be compromised, then you're talking about the FBI, the Idaho State Police, and the Moscow PD would have all three had to conspire to frame Bryan Kohberger, someone that no one had ever heard of before this. I'm just not buying it. And just saying it with no credible information, with no evidence, show me something that proves what you're saying. Show me some credible sourcing that shows that in some way that law enforcement is compromised. And you're welcome to share your opinion. And she does put it as her opinion, but I just want to push back on that a little bit because there's no evidence of that. And, when I'm covering the Chris Watts case and I covered the Alex Murdaugh case, I'm being told I'm against law enforcement. When I'm covering this case, I'm being told that I'm pro law enforcement. I'm not either one. I'm just interested in credible information because you guys deserve that. David says, so she can make his alibi go along with what the prosecution has. Exactly. Notice what she wanted. She doesn't have the full video from the prosecution. She has part of it. She says, before I give my alibi for Bryan Kohberger, I want all of the prosecution's videos so I can make sure he's not caught on CCTV camera. So whatever alibi we decide we're going to provide lines up with what the prosecution is going to present at court. No, you don't. That's not how it works. You don't get to have that. But apparently, if you're living in this county, I guess you do. Jane says he's in a nice, comfy jail. Definitely jail is better than a little 20-person jail. Is definitely a lot nicer than prison. That's for sure. He's more secure. He doesn't have to be worried about other prisoners. Only 20 other people in the jail with him. So yeah, I agree. Welcome, Marty Denton, to the Reporter Room family. I'm so happy you became a channel member. If you would like to become a channel member, just hit the join button and you can join. We have a private group on Facebook, and we also have a group for everybody on Facebook too, Reporter Room, if you want to join the conversation there. May says Ann Taylor will argue that she could not because the discovery was not fully handed over. Right. And she'll keep saying it's not fully handed over because what she wants and Jane wants to know, why is the 10-day rule being ignored by the court? I don't know. But it doesn't seem fair. The 10-day rule passed months and months and months ago. This discovery was turned over, and she still is saying she's going to give an alibi. But I want to see what the prosecution hasn't shown me on the video. So we know there's him on video, guys. We know that there's him on video. Because Ann Taylor more or less told us she wants to see what exactly they have him on video before we tell you his alibi. Right? So, yeah, she's going to continue to argue that discovery wasn't fully handed over. The judge has ruled what she's entitled to and what she's not entitled to. What she wants to talk about also is the IgG DNA. Notice what she doesn't want to talk about. She never talks about the fact that there was a court-ordered cheek swab that was, and BK didn't volunteer it. He didn't volunteer it. They had to get a court order to get his cheek swab, and that was compared to the DNA on the knife sheath. Somebody said that was compared to the DNA from the IgG. No, that was compared to the DNA on the knife sheath. So she just only wants to talk about the IgG because she wants the names of every poor person who whose name is in the database for that IgG, because she's going to try to put up what I call a straw man, which is simply it wasn't him, it was this person that did it. Look, their DNA is close to being a match, even though the cheek swab was done, and it is a match in the octillion, which is 27 digits after the first number, so 28 digits in total. Julie thinks it's sketchy to not give his alibi. I think it is too. And I think it's ridiculous that the judge is continuing to allow her more time to do it. I'm just going to advocate for the victims' families at this point, which is just that, we want a fair trial, but it feels like everything right now is leaning toward they were just grinning like cats with cream milk. Ann Taylor was just sitting there. I got what I wanted. I got everything I wanted. She couldn't believe it. I can't believe it. Marie says it's insane and not right at all. There is no formal alibi. Ruby says it seems to be all about the defendant. What about the victims and their families? When do they get a turn? This is so sad. Ruby, I agree. I feel so bad for the victims' families. I can't even imagine how frustrating it would be to be a victim in this case and have the defense just basically get everything that they wanted, and hearing that the defense team's claiming that when it usually takes 2 to 3 years to bring a capital case. Now, the prosecution offered March 3rd of 2025, so that would have been 3 years and 2 months after Ann Taylor got the case. So over 3 years, and they still wasn't enough. And then Jazz is welcoming you, Marty. Jay says, I kind of agree with you on that. Arlene says he's being treated better than the victims. Yeah, I agree. Sonia says, very frustrating. These 4 deserve their justice. Justice delayed is justice denied. I'm not saying he doesn't deserve his day in court. I'm just saying, is it going to be 5 years later after we've had witnesses pass away, after witnesses' memories fade? The defense benefits greatly by denying everything. Prison is a whole nother story. You're right, Jane. It really is. Hey, Morgan. Morgan said, if the venue changes, will the judge change as well? Or does the judge stay? He will stay. He didn't rule on that either. He just kicked the can down the road on everything except discovery. Amelia says there's 10 days from full discovery. Anne is saying there isn't full discovery. Anne is saying there is not full discovery. The prosecution is saying there is full discovery. But Anne wants to know, this is what she basically talked about, was the video. Run it back and listen for yourself. She wants to know if the prosecution has BK on video driving to or coming from that crime scene. That's what she's worried about. That's what she wants. She wants to know that video. And the prosecution's like, no, that's not the point of giving your alibi. You're supposed to give an alibi to let people know to exonerate yourself. It's not so you can find out every single thing the prosecution has on you, and then you create an alibi to work around that. So Ann Taylor can claim all she wants. She doesn't have full discovery. The judge has ruled that she does. The prosecution saying that she does, but she's going to continue to say that all the way. And she needs to delay. And she won today. She got everything she wanted. She got a discovery date. She got everything she wanted. She and the defense team, if you watch back, I wish we could have a closer zoom. The reason you guys don't have a close-up on this hearing is because Ann Taylor didn't want you to have it. That's why it was to protect BK's rights, just because I see people frustrated with the judge. He didn't decide that. I mean, he decided it, but Ann Taylor said that they were zooming in on BK and she didn't like it. Maybe because her client's affect doesn't seem right. I don't know. What do you guys think? Jane says, yep, no trial date set. I just can't believe we sat through that and we don't have a trial date. Michael said defense did not get the IGG. Michael, they got everything. The judge already ruled on this. She's just going to keep bringing it up because she wants that to be the headline. The defense didn't get my client's the underdog. He's being railroaded by everyone. The defense did get the IGG, but that's not even what the prosecution is going to be presenting in court. What they're presenting in court is the cheek swab DNA that matched to the DNA on the knife sheath. So that's just a distraction, in my opinion. Stubborn, wants to win at the cost of the victims. Well, she just wants to win. To her, this is a career-making case, right? After she wins this, if she can win this, she can write her own ticket. She can charge thousands of dollars, $1,000 an hour to get to, this is her golden ticket. So she wants to win. It depends on a capital case. I'm watching my words. A lot of time has already passed. Yeah, it's been 3 years. Spirit Walker says the judge just prevented any chance of an appeal at this point. So I think the judge is fair. Sonia says hello. Let's see. Let's get to comments. Amelia says it's a defense lawyer's job to defend their client. Other people's feelings don't come into it. Exactly. She's doing a great job for her client and they won today. They got everything they wanted. But man, it was, not getting a trial date set at this point is to me, it's, come on. Set the date. There's no reason a date can't be set. Marie says if he was innocent and had a strong alibi, they would want him to get this trial going sooner or later. Well, of course. And people keep saying, why isn't he out on bail? Because there's so much evidence against him. I think what she's doing, almost, in my opinion, I think it reeks of desperation because her only tactic right now is to try to find out if the prosecution has him on CCTV camera going to or coming from the 1122 King Road house and then create an alibi. That's what she wants to do. Jane thinks she's going to declare a mistrial. I don't know. I'm sure she's going to be, it's not fair to me the whole time. We know that's her strategy because she's been working it and doing a good job working it, in my opinion. Ann Taylor should be working on this case and no other cases. Jane says this will drag out forever if she keeps getting her way. Yeah. I mean, the prosecution gave her March 3rd, which is more than 3 years. Remember, these cases take between 2 to 3 years normally. So they gave her more than 3 years and it still was not good enough for Ann Taylor. She wants no date set. And they were just sitting there at the defense table. I wish we could have gotten a close-up because it was she was so gleeful. So gleeful. She couldn't believe it. Fair enough. Thank you. Thank you, Beach Life. And it's fine. You did say in your opinion, and it's okay. All opinions are welcome. I'm just talking. And I'm a little bit hot because I just can't freaking believe we just sat through this hearing. I aired this because I thought we were getting a trial date today. I just can't believe we sat through all of this and she got another delay. And she's claiming she's still going to provide an alibi, but she can't do it today, even though the 10 days passed months and months ago. She should not be allowed to then change the alibi. Now could I have the whole video that the prosecution's going to present to see if my client's on it? And then I'm going to give my alibi. And the prosecution's like, no, that's not the purpose of the alibi. You provide the alibi and we provide our case. You don't get to see everything if we have him on CCTV and then decide on the alibi. Lynn Ann says he's only brave with a K-bar knife in the dark. Well, he's winning today. Leslie says she's frustrated. Marie says there are one too many channels that cry. I don't know what this says. Sorry. Marie says not any evidence. Well, we haven't seen the evidence. Facts are facts. Rhinestone says, I don't agree with that. You have great input on these cases. Thank you, Rhinestone Girl. Those are just narcissists arguing with you. It's fine. It's fine. We don't all have to agree. Holly says there's a difference between the defense and stalling, and Taylor is stalling. Well, that's a defense tactic, is to stall, stall, stall. That's really common. Hey, Bravo Bree. Bravo Bree says, so far there's not been a lot of evidence that BK did this all by himself. It's only circumstantial so far. Well, we haven't seen the evidence. I keep seeing people say that. We haven't seen the evidence yet. There's a gag order on the case. I think the fact that he cannot get bail should tell you that there's strong evidence. Because if there wasn't strong evidence, he would be out on bail. They could set a $2 or $3 million. There's been no bail set in this case. There's been no bail set in this case. And that should tell you something about the prosecution's case. The fact that he has not gotten bail. Sonia says prison is not cool. No. So of course he'd rather stay in jail. In my opinion, the prosecution were very willing to work with Ann Taylor. Yeah. They came off the summer 2024 date and moved from June of 2024 to July, August, September, October, November, December, January, February, March. They moved 9 months to March 3rd of 2025, and Ann Taylor still said no. And Taylor will keep stalling. Yeah, she will. That's her tactic. That's her tactic. Marilyn says Ann Taylor thinks the trial will last 12 weeks. She doesn't imagine it as a slam dunk. If not a slam dunk, why delay? Arlene says the delays are getting old. It's time to set a trial date. They should have set it today. Holly Lynn says, are they coming back May 14th? Yeah, we're all going to be back here. I'll stream it again. We'll all be back here May 14th. And maybe then we'll get a trial date. Bryanston Cowgirl says she wants DP thrown out. Krista says it's totally frustrating. Spirit Walker says the proof is in the way the case was handled from the beginning. I think actions speak volumes. This guy would be facing trial by now if the evidence was complete. I disagree. I think the prosecution is ready to go to trial. They've said they were ready to go to trial. It was Bryant that waived his right to a speedy trial, not the prosecution. So I think the evidence is complete. I agree with that part. And I think the fact that bail has not been set speaks volumes for the evidence against Bryan Kohberger. And I think the fact that the defense apparently does not want to go to trial ever says volumes. So I think the evidence is complete. I just think the defense doesn't want to go to trial because they benefit from the delay. Witnesses' memories fade. Witnesses pass away. People retire. People move away. So Marty says, Ann's voice makes me annoyed. This witness thing in Lori Vallow's case, the defense had no witnesses. This was all annoying. I feel like the judge has bent over backwards. Yeah, I can relate to that. Mary Beth said, I heard her say that about the video. Yeah, she wants that video, the whole thing. And then I'll provide my client's alibi that I was supposed to give months and months ago. And you could just see the prosecution going, we're not giving you that. You're not getting that. Nice try, but you're not getting that. So you can make a defense, an alibi up around what we have. Holly says the prosecution has tons of evidence. Ann Taylor says she can't review it all. Yeah, you can't say on the one hand, I don't have everything that I want. And then on the other hand, but I have so much stuff that I need more than 3 years to go through everything. You can't have it both ways. I feel so bad for the victims' families. I'm sure they were hoping a trial date was going to be set. That's it. The trial date could have been set today for March of 2025, something, but she won. Amelia says comprehensive info and analysis on this case. Thank you so much, Amelia. Give this a thumbs up and subscribe to Reporter Room. Dollar says he should be in jail for the length of time this case is taking. Well, he is in jail. You can be sure he is in jail. Morgan says, I'm irritated. He hasn't set the date and seems to be fueling Ann Taylor, but I think the judge is being extremely patient, cautious to set the date because he wants to do this right the first time. Yeah, he doesn't want to be overturned on appeal, but I don't think it would have hurt to set the date. I think 3 years, which is what the prosecution moved off their summer of 2024 date, gave them 9 more months to March 3rd of 2025. I think that was reasonable. Bravo Bree says, sorry, but what video do they have of BK? A vague video of a car they couldn't. No, you've only seen one video. There's more. She knows, Ann Taylor knows there's more videos. She knows there's more videos, and she wants to see the videos that the prosecution has before she gives Bryan Kohberger's alibi. I'm sorry, but that's not the purpose of an alibi. You say where you are and what you were. You don't get to see all the videos first and then decide what your alibi is. You don't work your alibi around the evidence. You have an alibi or you don't have an alibi. So Florence feels like this is disgusting. I don't know. I just think it's frustrating. Arlene says, Ann Taylor has 2 other attorneys working with her. She has more than that. She has a team. I think it's 9 attorneys. My missing piece says, how do you know that's all there is? Where he says, you are so real. Thank you. Thank you. Hey, great stuff. Great stuff says, Fanny needs a lesson from the court. I don't know. I think she got everything she wanted. They were just like cats that got the cream. They were like gleeful, the defense team, once they realized that no court day was going to be set. They didn't have to provide the alibi, and they still get to have all the discovery date set. But even after that's done, I guarantee you she's still going to be complaining she doesn't have everything and she needs to delay, because that's her game. That's a common defense tactic. And I don't mean game in an unprofessional way. That's her job, is to delay. Morgan Gross says, yeah, why hasn't the judge said for her to hire more help? Well, she has 9 attorneys. Didn't the judge think that that was his alibi? Have I misheard? Yeah, I know. Well, apparently she wants to provide another one. And that's where I saw the prosecution get really frustrated. Not getting a date. They gave her 9 more months. But it is ridiculous. I feel so bad for the victims' families. I really do. And each attorney has a paralegal to help them too. Oh yeah, she has staff. She has staff helping her. She's not doing this by herself. Their family must be more. I don't know what that says. The prosecution did not push back very hard today. What happened there? I don't know, Spirit Walker. I think they did, but the judge is going to do what the judge is going to do. Pam says, I think often the victims are forgotten with the idea of protecting the defendant's rights. Yeah, I think it's good to protect the defendant's rights, but there are victims' families who have lost their children. They have lost their children. And, I think they deserve, and again, a case like this normally takes 2 to 3 years. The prosecution offered more than 3 years today, and that still was not good enough for Miss Ann Taylor. Lauren says, I think the evidence is just so overwhelming against him. That's why he's okay with staying in jail that long. Right. If it wasn't overwhelming evidence, that he would be out on bail. He doesn't have bail. And I think that her tactics, to me, they reek of desperation. In my opinion, I think she's desperate. She doesn't want to she can't give an alibi for him till she sees the prosecution's videos. So that's what she wants now. She's not asking for discovery. She wants to see their whole case before she provides an alibi. And that's not right. That's not the purpose of an alibi. Hey, Lori. Lori says, I agree with the state. BK wants to see what they have before he makes up an alibi. That really says a lot about his guilt. Amelia says, why do you think wasn't prosecution more vocal their certain disclosure is complete. I don't know. I don't know if they just felt like they felt like they did have their say. They can't control what she's saying, what she's doing, and they may know this judge better than we do, and just know that he's gonna side with the defense. So there wasn't no point in alienating the judge. I don't know what their thought process is. This is just me thinking out loud. Yes, those poor families. Yeah, it seems like they're being forgotten in all of this. Dollar Shin says, I don't know the difference between jail or prison, but he should be wherever they have him charged with. Well, he's in jail. Jail's a lot nicer than prison. In prison, he would be, with a lot more people than 20 people. He probably wouldn't be getting vegan meals. He wouldn't have a TV. He wouldn't have his tablet and all that stuff. Hey, Yusakiwi, the judge was basically saying to Anne, she has all the evidence. She just has to dig for it. Well, she wants to know, she wants that video from the prosecution. Then she'll give his alibi. Once I see if they have my client on CCTV camera, then I'll give it. Marty says, I guess perhaps in his defense, I believe the judge was beyond frustrated. However, yeah, I don't know what to think. Me Megger says, right, they aren't going to serve it up on a silver platter. Oh, you're welcome, Lori. I'm glad we got to stream today. I'm going to stream the whole trial. And I'm going to be doing another live stream on this case on Sunday. If you haven't subscribed, please do, and hit that notification bell so you don't miss anything. Lennon says, well, the case probably won't go to trial until 2027. Yeah, maybe someday. Thank you, Mike. All right, guys. Well, I'm going to leave it there. Thank you so much for joining me. I just want to say thank you to our producers, George, Brown, Jane J, Sasha Angel, our awesome channel members, all of you subscribers, and our mods and our head mod, 6 Cents Amelia. Thank you so much for your help today. If you want to have your name appear here, you can hit the join button and become a channel member. You also get a check mark next to your name. That's where you see the check marks up and down in the chat. All right, guys, I will see you on, I have a new video on Bryan Kohberger coming out tomorrow. And then I will see you on Monday